Good morning. I'm Brandan Tran, Director of Public Affairs and Outreach for Campaign Life Coalition. Bill C-9 was introduced in the House of Commons on September 19, 2025, as a measure purported to combat hate. However, the criminal code already covers most of the conduct C-9 targets. Bill 423 prohibits intimidation to compel or restrain conduct. Section 264 defines and prohibits criminal harassment. Section 430 defines the offense of mischief, covering interfering with lawful use of property. Section 175 criminalizes causing a disturbance in public places. With these sections taken together, police officers already have the tools to charge someone who intimidates worshippers outside a synagogue or blocks access to a church. Bill C-9 is, in large part, a solution in search of a problem. On hate crime sentencing, existing sentencing law already requires courts to treat evidence that an offense was motivated by hatred as an aggravating factor at sentencing. C-9's standalone hate crime offense, with its escalating penalty structure, is novel and unnecessary, as the principle that hate motivation worsens a sentence is already in law. Further, Section 319, subsection 2, criminalizes the willful promotion of hatred against any identifiable group. Bill C-9's new symbol display provision extends what the law will consider willful promotion of hatred to displaying specific forbidden symbols in public. The willful promotion of hatred against an identifiable group is already an offense. While the bill may today identify symbols of groups outside the consensus of progressive liberal democracy, once a list of hate crime symbols is in place, a future parliament can put the symbols of more and more groups on that list. For example, a future parliament could make it a criminal offense to display the image of Sir John A. Macdonald. Perhaps a future parliament will introduce a bill to add to the list of forbidden hate symbols the Canadian Red Ensigns, the flags under which more than 1 million Canadian soldiers fought, the flags under which more than 100,000 Canadian soldiers were killed in the First and Second World Wars. Now, our central concern is the repeal of Section 319, subsection 3b, the good faith religious speech defense. That provision has protected Canadians from speech prosecution when expressing a sincere opinion grounded in a religious text. It was never successfully invoked in court to escape a legitimate conviction. Removing it solves no legal problem. What the removal of the good faith religious speech defense does is eliminate an explicit boundary in the law, one that told citizens, police, and prosecutors that this category of speech carried statutory protection. In its place, Bill C-9 offers a clarification clause stating that religious speech isn't prohibited, provided it doesn't say something that the bill prohibits. Conservative MP Andrew Lawton called that circular reasoning, and he's right. Whoever files a complaint and whoever decides to prosecute will get to decide whether deeply held religious convictions constitute hate crimes. Cardinal Frank Leo put it precisely, writing that repealing this defense risks creating uncertainty for clergy, educators, and all people of faith who seek to pass on the teachings of the Church with charity and integrity. We know what the government intended because they said it plainly. On October 30th, 2025, Marc Miller, then chair of the House Justice Committee, told the committee on the record that passages from Leviticus, Deuteronomy, and Romans contain clear hatred towards, for example, homosexuals, and that the good faith defense should not be used to invoke or be a defense. The Liberal government then struck a deal with the Bloc Québécois, bloc support for the bill, in exchange for a bloc amendment, removing exactly the protection Miller had criticized. During House debate on March 23, 2026, Liberal MP John-Paul Danko named anti-abortion hate as a category of expression the bill is designed to reach. These interpretations of the bill's implications are statements made by the parliamentarians who passed it. The chill effect Bill C-9 produces doesn't require a single prosecution. A pastor reviewing his homily, a catechism teacher presenting Catholic moral teaching, a pro-life advocate on a public sidewalk. None of them need be charged for this suppression of free speech and religious belief to work. Legal ambiguity falls unevenly, and it will land hardest on those whose sincere religious convictions place them in tension with prevailing ideology. Under threat of prosecution, Catholics, Orthodox Christians, and others who hold traditional teachings on life, marriage, and family will think twice before expressing their deeply held religious convictions. Many will self-censor. That is the suppression of religious freedom. That is the suppression of free speech. Campaign Life Coalition stands with Citizen Go, the Canadian Conference of Catholic Bishops, the Catholic Civil Rights League, the Christian Legal Fellowship, the Justice Centre for Constitutional Freedom, the Evangelical Fellowship of Canada, ARPA Canada, and many others in opposing this bill. Senators, what legal problem does removing the religious defense actually solve? Bill C-9's own legislative history answers that question, and the answer has nothing to do with combating hate. Bill C-9 is a threat to religious freedom. My fellow Canadians, contact your senators today. Thank you, and God love you.